So the Supreme Court has just punted on another Second Amendment case. In this video, we're going to be talking about the New York State Rifle and Pistol Association v. New York City. This was a major Second Amendment case that we had pending before the Supreme Court. The Supreme Court had granted cert and we were waiting on what exactly they were going to say. Well, today we got their opinion, and what they did is essentially what they have been doing a majority of the time on these Second Amendment issues, and what they did is they punted on the issue again. So I'll actually put a link to the opinions down the details if you want to take a look for yourself. So for a quick background, what exactly this case involves a New York City ordinance. And what this New York City ordinance did is it required a premises license for individuals, and it only allowed you to take your firearm to specific gun shops or firing ranges within the city limits, and really was only, I think, one where residents could actually shoot at. And it also put a limit on individuals from being able to transport their firearms outside the city, outside the state. So what happened procedurally, and really what this decision is it is a decision based on the procedure merits. They don't address the Second Amendment merits at all, the majority opinion. They just kick the issue down, saying that this law is moot, because what the state actually did is, once the Supreme Court said that they were going to grant cert, which means that they were going to take and hear this case, the New York City actually got rid of their ordinance, saying that, well, it wasn't valid. And the state of New York actually went in and actually issued a law saying that what the city did was illegal as well. And ultimately why this was done is because they wanted to argue this mootness. They wanted to argue that the case before the Supreme Court is moot. It was a strategic measure by the state and by the city of New York. And why this was done is because how this got to the Supreme Court was based on the plaintiffs were seeking an injunctive relief. And for those of you in the state of California, you're very familiar with individuals seeking injunctive relief or wanting to put a hold on the law's effect. And so how this got to the Supreme Court was the plaintiffs were seeking injunctive relief from the law and from it being enforced on them, or from them not being able to transport firearms or having to comply with these specific city laws. So essentially what they're arguing based on mootness is that the plaintiffs have already gotten what they are asking for in the lawsuit, and therefore their lawsuit is moot because they've already gotten what they are asking for. So why this is a big loss for the Second Amendment is because this case was the first one that the Supreme Court has decided to hear in a long time. The Supreme Court has not been addressing these Second Amendment issues. So a lot of us were anticipating that, especially with Kavanaugh on the court, and we'll address kind of Kavanaugh's approach to this as well, but a lot of us were hoping, since Trump has put in new justices on the Supreme Court, and that the Supreme Court is now leaning more towards conservatives and what we thought were individuals who would support the Second Amendment, we thought that we could get more language that would help us down the road for some other Second Amendment cases. But that was not the fact here. What actually happened is Kavanaugh agreed with the majority, saying that the issue in this case is moot, that the individuals have already received the relief that they are seeking, and therefore it should be kicked back down to the lower courts without really addressing any of these Second Amendment issues. It is shocking because, if you are not aware, Kavanaugh is the individual who sat on the District of Columbia Appellate Court, and in the Heller v. DC case, which is one of the pinnacle Second Amendment cases that we've gotten recently, in that lower court decision, Kavanaugh dissented on the majority, saying that that law, which was in effect in the District of Columbia, violated the Second Amendment. And a lot of his language was used later by Justice Scalia. So in his concurrence, Kavanaugh actually says, "And I share Justice Alito's concern that some federal and states courts may not be properly applying Heller and McDonald. The court should address that issue soon, perhaps in one of the several Second Amendment cases with petitions for certiorari now pending before the court." So Kavanaugh here is saying the issue is moot. I agree with the majority saying that this issue is moot. He agrees with Justice Alito's dissent, saying that he agrees with Heller and McDonald and the way that Alito is interpreting Heller and McDonald. And he's saying that there may be some cases where they need to soon look at how the lower courts are applying Heller and McDonald, but he's saying not here, which is confusing. If he thinks that these issues need to be addressed, why didn't he address them here? And I really don't have a good answer of why he concurred with the majority here. I can only speculate that maybe he thought that this case wasn't a good foundation to argue these major Second Amendment issues that we need addressed. Now, another major takeaway with this, and what's really scary about this, a lot of people are just focusing on the fact that the Supreme Court did not decide on the Second Amendment merits. And what's very scary about this and what actually Justice Alito hints at in his dissent, is that the Supreme Court might have just opened up an avenue for states, for cities, to avoid the Supreme Court from actually getting to address these Second Amendment issues. For example, here in the state of California, we have multiple Second Amendment cases that are pending before the Ninth Circuit. Recently, we just had Roe v. Becerra get to the Ninth Circuit. Roe v. Becerra addresses the ammunition restrictions in the state of California. We also have Duncan v. Becerra, which is in front of the Ninth Circuit, which oral arguments have been heard on, and that addresses magazine capacity in the state of California. Let's say that the Ninth Circuit does not agree with our side and says that the laws do not violate the Second Amendment. And then the plaintiffs in those cases actually seek cert from the Supreme Court. What the state of California could then do is say, okay, we're going to get rid of those laws, which might be a short-term win for us because then the magazine capacity and the ammunition restrictions would go away for a short time. They could say, Supreme Court, you can't address these because those issues are moot. The Supreme Court would say, yes, we agree they are moot. It gets kicked back down. And then down the road, the state of California just enforces another type of law with maybe some tweaks or something like that. And then you have to go through the process all over again. And really could lead to this vicious cycle of the Supreme Court never really getting to address these Second Amendment issues, because anytime the Supreme Court's about to take it, the state or the city or whatever goes ahead and gets rid of the law in the meantime, and then argues that the relief being sought is no longer valid. So this is a big loss for us, not only because we didn't have the Supreme Court address Second Amendment merits or address any Second Amendment arguments really like we were anticipating they did, but also they might have opened up the door for future cases to also be kicked and opened up an avenue for the state and cities to avoid the Supreme Court from actually getting to decide these Second Amendment issues. What Justice Alito and the dissent individuals say is that the city's travel restrictions burdens the very rights which were articulated in Heller. He says that this city ordinance and that the laws regarding restriction on transportation and in and out of the city or taking them to ranges and the types of firearms that are addressed in this specific case directly align with Heller's decision. And that he says that the city's public interest that they had put forward as a rationale for this specific ordinance was very weak. They didn't have any merit. And the reason why they are doing and arguing what they are now is because there was no basis for that ordinance. And also he specifically addresses and talks about the use of Heller and the use of McDonald in the lower courts. And this is really why we wanted this case heard, because we wanted more direction by the Supreme Court saying how the lower courts should apply Heller, should apply McDonald in these Second Amendment cases. But what Alito and the other dissenting members are saying is that the lower courts have been misapplying Heller and McDonald, similar to how the lower courts here in this specific case have misused Heller and McDonald, how they are not probing into the specific issues and the specific rationales of why these laws are being put into place and how they might actually infringe on the Second Amendment. They are saying that these types of cases need to be probed into more, and that the lower courts are straight out pretty much misapplying Heller and McDonald and just ignoring what the Supreme Court has told them they are supposed to do. And now we have to play the wait and see again for another Second Amendment case to be granted cert by the Supreme Court, and hopefully that one doesn't get punted on again, or hopefully there's not a similar situation like that has happened here, and that the Supreme Court, with the help of justices like Alito, Thomas, Gorsuch, and hopefully Kavanaugh, will actually address these Second Amendment cases on their merits and not just try to find a way out. And we also got some opinion from Alito and some from the dissenting members as well about why this case is not moot, like the majority, like Kavanaugh and his concurrence, say that this case is moot. Alito, in his opinion, said that they could have addressed some of the damages issues. Also, he says based on some of the attorney's fees issues, they could have addressed this as well. So the dissenting members did not see this as moot. So I hope that helped you guys understand why this is such a big loss for us and why this might have some greater implications down the road, especially for some of us like us in the state of California, where we have a lot of these Second Amendment cases pending before like the Ninth Circuit, and how now these states and cities might have an avenue or a mechanism to avoid the Supreme Court from hearing these specific cases. If you like this video and you'd like to support the channel, the best way you can do that is to join my Patreon. I'll put a link to the Patreon down below. Another way you can support the channel is using the various affiliate links also found in the details section. If you have any questions, go ahead and write down in the comment section. I'll try to address them to the best of my ability. So as always, thanks you guys for watching. Don't forget to like and subscribe, And never forget, a nation that draws a great distinction between its scholars and its warriors, while its laws are run by cowards and its wars fought by fools.